sit. All right, Ms. Green-Cross, you may proceed.
Thank you, Your Honor. Dr. Flores, you weren't here when Dr. Browning and Dr. Huey were testifying, right?
Correct.
And have you reviewed that testimony?
I have not.
Anybody tell you what they testified to?
I discussed with Ms. Sanson some of the issues that were brought up in their testimony.
In preparation for testimony today. All right. So when you critique the work that was put in or the material that was reviewed or the sequence of events for Dr. Huey and Dr. Browning's evaluation, are you just basing it off the report?
I'm basing it based on the report and the fact that, to my knowledge, additional information was not reviewed.
Okay. So, and you don't know what was reviewed or not reviewed. All you know is what's in the report, right?
What is in the report, yes.
Right. Okay. And you reviewed that report?
I did.
Okay. And you know it was 22 pages?
It is.
All right. And you did a report in the case, right?
I did a summary in the case.
You did a report?
A summary in the case.
When we testified earlier about a report being dated on September 30th, 2011, we're talking about the same document, right?
Right. It was a summary report.
It was. Did you do another one?
No.
I've got a 5-page report here. Is that the report you're talking about?
That is it.
Okay. And so you didn't do another one after that?
I did not.
So any of the work you've done in 2016, you didn't update your report. You didn't do anything other than the written documentation I'm holding right here.
My update is the information that I'm providing this week.
That's right, because you're testifying to things maybe not in your report, right?
Correct.
Yeah. And this is the report, this is the opinion you concluded prior to the testing, or you reached your opinion in this case prior to the completion of the testing of the defendant for malingering, what you just went over with Ms. Sanson, right?
Correct.
All right. Now, in your report and in your testimony today, you never diagnosed the defendant with PTSD, post-traumatic stress disorder.
I did not.
That came up today, but you haven't diagnosed this defendant with that.
He does not meet criteria, correct.
Okay, all right. And you talked a lot about delusional disorder. You didn't diagnose this defendant with delusional disorder.
I did not diagnose.
You don't think he has that?
I think he has delusions.
You don't think he has delusional disorder?
Not delusional disorder by itself.
No, because he doesn't meet the criteria for that, right?
He meets the criteria for delusions.
Does he meet the criteria for delusional disorder?
He does meet the criteria for delusional disorder.
Are you now diagnosing him with delusional disorder?
No. What I am saying is that he has bipolar disorder, most recent episode manic with psychotic features. The psychotic features being consistent with what you would see in a delusional disorder.
That's what you said, right? That's what you reached your opinion on back in 2011.
Back in 2011, and I still stand by my opinion.
Yes, I see that. And you were paid $25,000 for your opinion in this case, right?
I was paid $5,000 flat fee the first time, $20,000 this time. It would have been more like a $75,000 case.
It's a $75,000 case?
It should have been for all the work that I put in.
You must feel tremendously cheated.
No, I don't feel cheated. I think that I've done the right thing by testifying.
Thank you, Dr. Flores. Thank you. Hey, in the exhibits that Ms. Sanson showed you, Defense Exhibit 41, 42, 43, I want to put those there in front of you and ask you to take a look at them for me. Do you recall seeing these documents before?
I do.
They're pages from the DSM?
Yes.
And this court jury has heard a lot about the DSM and how it's used in the field of psychiatry and psychology to diagnose mental illnesses, right?
Yes.
And where in any of those exhibits does it talk about a rescue delusion? Can you take a look at them and see for me?
On these particular ones, it doesn't. I think if you look under bipolar disorder, I think there may be something under for rescue delusions.
Do you recall testifying specifically the other day that rescue delusions was a kind of recognized delusion and it's referenced in the DSM-4, or DSM-5, excuse me?
It is, and if we look at the DSM-5 under bipolar disorder, I believe that there may be some indication, some mention under that particular subheading.
Can I approach the witness?
You may.
Okay, Dr. Flores, I'm going to hand you my copy of the DSM-5. Would you take a look in it for me and see if you can find rescue delusion?
Sure. You give me 1 moment.
I'll wait.
Is it at all possible to take a couple of minutes? Because I know it's in here.
I'll wait.
Okay. It may help if I look at my purse where I have, I think, the actual,
You think you might have the page number there?
I might actually have it highlighted for rescue delusions.
So you say you want to see?
I don't have your purse.
It's over there.
Maybe it's in those notes. Did you bring the notes that you brought the other day?
No, because I've already testified to those notes.
Did you need to come down and retrieve your notes or something?
If I may, Your Honor,
You may come down.
it might be faster. I think I may have something in there. Okay.
What you're getting there, Dr. Flores, is that all your notes?
One second. Let her.
I'm sorry.
All right, she's back in the witness stand. You may ask questions. Go ahead.
I'm still looking for it. It's several pages under bipolar disorder, and that is where they do discuss the rescue delusions potentially occurring, particularly during a manic episode.
Okay, when you find that part in there, I just have a question or two about it. That's okay, Dr. Flores. I can ask another question.
Okay. I'm sorry, it's just several pages of
I understand.
information.
You testified just a few minutes ago that memories change, right? You wouldn't expect somebody's description of an event to be consistent over time because memories change, right? That's what you said?
Memories can change, yes.
Memories can change. Malingerers change their story, don't they?
They can, yes.
They do, right?
I said they can.
And they do? In your experience, have you ever come across an individual who's malingering who has changed their story?
They will be you will see inconsistencies.
Over time.
It could be over time. It can be in the same interview.
It can be. Okay. Thank you, Dr. Flores. I don't have anything else.
You need to redirect. The lawyer has made his witness be released and excused from her subpoena. Do you want her to remain on subpoena?
She may be excused from the statement. She may be excused.
Thank you, Dr. Flores. You're excused. Did you want to take your book?
I will. Thank you.
All right, Ms. Sanson, or Mr. Lamb, or Mr. Blank, are any witnesses?
We have no further witnesses to address.
All right. Ladies and gentlemen, the defense has rested. Is there anything else from the state?
No, Your Honor.
All right. All right, ladies and gentlemen, at this point in time, both the state and defense have rested. The next portion of the trial will be closing arguments. But I have to go over some matters with the lawyers before we do closing arguments. But based upon some other factors, what I'm going to do is go ahead and conclude your involvement for this session for today. Let me just give you some insight. The law allows both sides to have up to 2 hours for concluding remarks, which is a total of 4 hours for closing argument. But based upon all the facts and circumstances, what I'm going to do is go ahead and dismiss you for today. Thank you for your patience. Thank you for your positive attitude. And let me give you these instructions. Do not discuss the case or allow anyone to discuss the case with you. I fully understand the weekend is coming up. You've been through this weekend with us before, so you know what I'm going to tell you, so I'm going to tell you. If you do decide to have a meal here in Decatur or anyplace else over the next day or 2 days, do not sit next to anyone who may be discussing the case or allow anyone to sit next to you who may be discussing the case. Do not remain upon the floor when I release you at this point in time, because I don't want you to hear anything or see anything you should not hear. Do not read or look at any media coverage pertaining to this case. Do not go upon the internet and do any research about this case. Do not blog or write about this case while it's ongoing. Do not go to any location that may or may not have been made reference to. The evidence has closed at this point in time, but all the evidence has come to you in the form of sworn testimony from this witness and any physical evidence that was introduced during the course of the trial and on any stipulations that were agreed to by the lawyers. You're more than welcome to bring something to stand and eat with you come on Monday. But do not consume any alcoholic beverages during the lunch break, and do not overindulge in any alcoholic beverage over the weekend that would impact or impair your ability to focus. When you do return on Monday, just make sure you turn your cell phones into the off position, bless you, so that they will not be disturbing us during the course of the proceeding. As I had mentioned to you during initial remarks, we've gone through board opening statements, presentation of evidence. The next part of the trial will be what is called closing arguments. After the lawyers have given closing arguments, I will tell you what law applies to this particular case. And then at that point, and only at that point, you would actually start your deliberation. So do not discuss the case. I'll allow them to discuss the case with you. And I do want to thank each and every one of you again for A, have a positive attitude, B, keeping an open mind, and C, following my instructions. And all of you have been on time, and I really appreciate it. With the assistance of Deputy Moore, I'm going to go ahead and let you have your telephones and communication devices, and you can go ahead and return messages and phone calls and things of that nature. Please leave your notepads there in the jury room, so face down. No one's going to look at your notes. They'll be there. No one's going to check your notes. You, as far as the jurors, are going to be on recess until I see you again Monday morning at 9 o'clock a.m. And at that point in time, we should go into the boards will have an opportunity for closing arguments. And then after that, then I will tell you what law applies to this particular case. And after that, then you would actually start your deliberation at that point in time. Any questions? Wonderful. Hearing none, follow the instructions of Deputy Moore. I will see you on Monday morning at 9 o'clock a.m. Monday, 9 o'clock a.m. Have a wonderful afternoon and a wonderful weekend. I will see you Monday morning, 9 o'clock a.m. Remember, you can be early, but you can't be late. 9 o'clock Monday morning, no one's been released, no one's been excused. I will see you Monday morning at 9 o'clock a.m. You ought to be able to complete my sentence by this time. Be early, but you can't be, you're right, late. Drive safely. Lawyers, approach momentarily before we start our charge conference. Everyone's can have a seat. All right, Kelly, we're back on the record, and I do want to thank everyone for their patience. Lawyers, what we will do at this point in time is go ahead and have the charge conference, and we will go over the proposed request for charges. I do want to thank both the state and the defense for submitting the proposed jury charges to my staff attorney, Ms. Jeffries, and she was able to print those out and provide a copy to me. And Ms. Jeffries has, and she's present, and she will go through this. Lawyers, where we normally proceed. Just doing this refresh your memory, as you know, we've done this many times together, not on this case, but on other matters. I will go through the proposed request for jury charges for the state, and then the defense, and each side will have an opportunity to either A, supplement or state their objection. The proposed, who's going to speak on behalf of the defense? All right, wonderful, Mr. Lamb. And lawyers, for the purpose of this, feel free to express yourself quickly and verbally and to the point. Any objection to state number one? I'm just going to call it by number because you have it in front of you. Objection number one?
No.
Number two?
No.
Number three?
No.
Number four?
No.
Number five?
No.
Number six?
No.
Number seven?
No.
Number eight?
No.
Number nine? Okay, on number 9.
I'll withdraw that one, Your Honor. It didn't end up applying.
Okay, so number 9 is withdrawn. So if it's withdrawn, they have a right to withdraw. Number 10.
Was anybody?
Any objection to number 10? For the purpose of this, was any?
I don't recall anybody being impeached.
Ms. Vanilla?
Your Honor, there was definitely Dr. Flores was impeached with her prior testimony when she said that the defendant didn't say that it was for the purpose of him being with Andrea in marriage and raising the kids together. And then once she was shown her prior testimony, she changed her statement.
Then no objection.
All right, and there are two versions. Well, not two versions, it's a or section. Ms. Venuto, you want me to go to the first paragraph, which reads, I'll start and read it so you can hear it. To impeach a witness is to show that the witness is unworthy of belief, period. A witness may be impeached by disproving the facts to which the witness testified, semicolon, or the credibility of a witness may be attacked by disproving the facts to which the witness testified.
I believe it would be the second part that would apply, Your Honor.
All right. You're asking for the latter?
Yes, Your Honor.
Ms. Delaney?
No objection.
All right. Ms. Jeffries, we will put down the latter as far as the credibility of the witness may be attacked by disproving the facts to which the witness testified. Also, going back to, so we have that. That's all. All right. The expert witness will give it in its entirety. I don't think there's no exception to this. The expert witness will be given Ms. Jeffries in its entirety. All right. Number 11, lawyers. The state is requesting prior statements.
No objection.
All right, we'll give. Number 12, any objection to single witness corroboration?
No.
Number 13, identification reliability.
No. sure if identification is an issue in this case, Judge, but I guess I don't have any
Ms.
objection.
Venuto?
Your Honor, I put that in there because Jan De Silva ended up identifying the defendant both through a photographic lineup, and I believe several people identified him in court.
They have a right to ask for it. I'm going to give it. Technically, it's in the case. I understand, based upon the nature of the defense, there was a certain amount of admission that he didn't do that, but it's still something the jury may consider, so I will give identification reliability. Number 14, any objection, Mr. Lane? On the identification burden of proof, we'll give. All right, the pattern language on definition of a crime, any objection?
No.
Any objection, number 16?
No.
Number 17?
No.
Number 18?
No.
Number 19 on venue?
No.
All right, number 19. Any objection, 20?
No.
Okay, what do we have here? Okay. Any objection to 21?
No.
22?
No.
23?
No.
24?
No.
25?
No.
And 26?
No.
All right. I thank you, Mr. Jeffers, I'll mention that in a minute. As far as number 27, malice murder definition, that is it's 2.10.10 malice murder defined. Any objection to that definition, Mr. Lane?
No.
All right, we'll give Mr. Lane any objection 28 as to the pattern language on motive.
No.
This is number 29, felony murder. Is that withdrawn, Ms. Venuto?
Your Honor, may I have 1 moment?
Sure you can.
Your Honor, we'll withdraw 29 and 30.
All right, 29 is withdrawn, Ms. Jeffries, and 30 is withdrawn. 31, any objection, Mr. Land? You have it in front of you. Now, what I had, when I read it, and Ms. Jeffries went over it, also, there's only 8 that's going to apply to this
Correct.
case.
That's correct, Your Honor.
So the state is withdrawing B, C, D, E, and F. Is that correct?
Yes,
Ms.
Your Honor,
Venuto?
we would ask to tailor it to the actual case. Actually, the whole
All right,
charge.
we give thank you, Ms. Jeffries, for catching that. Any objection to now 32? Any objection to 32?
No, Judge.
All right, that will be given, Ms. Jeffries. 33, voluntariness defined.
No objection.
All right. 34,
No objection.
and Ms. Venuto, are you asking for that to be given in its entirety? Because that, if you look at 34, that's parentheses, says, however, under the law, in order for a statement to be excluded because of illegal detention, it must be shown that the statement was, in fact, induced by such illegal detention.
Your Honor, I don't believe that parenthetical part applies to this case. I don't think that there's any indication in the case that the statement was based on illegal detention, so we would ask that that part be, we would withdraw that portion or ask
Ms.
for it.
Deland? Yeah.
I would agree with that.
All right, that will, I'm crossing out it also, and Ms. Jeffries making a note also. All right, 35.
No objection.
We'll give 36, Mr. Lane, any objection?
No.
We'll give constitutional rights. 37,
No.
burden of proof as to rights, we'll give, no objection. Number 38. Any objection to 38, Ms. Jeffries? I'm sorry, I said Ms. Jeffries, but Mr. Lane?
No.
All right, we'll give 38. All right, number 39, this definition of insanity at time of commission of offense. It reads, every person is presumed to be of sound mind and discretion. However, this presumption may be rebutted. Any objection to 39?
No, Judge.
We'll give. Anyway, we're going to keep reading. Now, when you go to the second page on that, when it gives the options of possible sentence, I deleted E as in Edward.
I have no objection to that, Judge.
And Your Honor, we have no objection. If you're going to delete it there, we would ask that in the portion above it where it says that if you find at the time of the alleged criminal act the defendant was suffering from insanity, mental illness, or mental retardation, there's been no evidence of mental retardation. I just wanted to, if we're going to withdraw
Do
E.
you agree with that,
Yes.
Mr. Lane? All right, so the word, I'm going to adopt the word or mental retardation, so it's going to read, if you find that at the time of the alleged criminal act, the defendant was suffering from insanity, Now, what I would do is insert the word or, mental illness. You see where the insertion is going, Mr. Lane?
Yes, Judge.
All right. And I'm going to leave the word, and I agree with Mr. Benuto, there's been evidence, at least up to this point, about retardation. Then you shall determine whether the defendant is A, not guilty, B, not guilty by reason of insanity, C, guilty beyond reasonable doubt, D, guilty beyond reasonable doubt but mentally ill. And it stops there.
Your Honor, in that next small paragraph, there's also the mention of being mentally ill or mentally retarded. We would ask that it be removed from that portion as well.
That will be deleted also. All right, and that comes down to now. With those changes, does everyone understand the changes that are being made to the language?
Yes, Judge.
Yes, Your Honor.
So, all right, 40.
No objection.
All right, we'll get 40 as written. In its entirety. Excuse me, I have read on that last paragraph, should you find, etc. All it was given in its entirety, Mr. Jeffries. 41.
Judge, I don't think that's not an issue in this case. That's not something we will be arguing. So I don't think there's any reason to confuse the jury with that.
Your Honor,
Mr. Newman?
Dr. Flores' entire testimony was about the defendant being delusional. And I think it is something that the jury should hear. That is a huge issue in this case as to whether or not he was delusional before, during, and after. She said he was delusional from the time he saw the angel in July straight up through until September when she saw him, or I'm sorry, October when she saw him in 2011. So the delusional issue is an issue in this case. And they also testified about the different ways that a person can be delusional or manifest itself, and that is definitely an issue in this case.
Yes, Mr. Lamb.
Judge, again, this charge goes specifically to the defense of a delusional compulsion, and that has never been our defense in this case. And that's what this charge is defining. And again, I have no intention of arguing that he was suffering from a delusional compulsion.
Actually, Your Honor, one of the questions that this charge raises, it talks about that in that last paragraph there on page 8.
In order for mental delusion or delusional compulsion to constitute a defense, it must appear not only that the accused was actually laboring under a delusion at the time of the commission of the alleged criminal act, but that the alleged criminal act itself was connected with the particular delusion under which the accused was then laboring, and that the delusion was as to a fact that, if true, would have justified the alleged act by the accused. This is a question of fact to be determined by you.
And, Your Honor, what that relates to is that the defendant claims that he was suffering under the delusion that the children were in danger, he needed to protect the children, and he needed to kill Rusty Sneiderman in order to achieve that. The jury has heard a ton of evidence about delusions, and they need some sort of legal framework to know how that fits in or what that is about. I mean, if we just don't give them any jury instruction on delusion or how it relates, that would be not giving them the full picture of what is involved here with the delusion.
And Ms. Benuto, on that request that you had, at the bottom it does have parentheses, here defined justification claims.
Mm-hmm. Yes, sir.
Defense of self or others, which is 16-321. Defense of habitation, 16-323, which is not going to be applicable. Or defense of property.
Yes, Your Honor, and then that's that last portion, that last bold-faced portion that begins on page 8 and goes into page 9. Justification. It defines it because it says here, go ahead and define what you're talking about. And here we're talking about justification in his mind, use of force in defense of others. And so I put that in here as well.
I understand. Mr. Lane?
Judge, we're not arguing that this was defense of others. I understand what the testimony was, obviously, and I understand where Ms. Benuto is going. However, it is not our position that he would have been justified in the alleged act. So, again, we are not arguing, have never argued that he should be found not guilty by reason of insanity because of a delusional compulsion, which would then require you to give this charge and the self-defense charge. That's not our position. It's never been our position.
But in fairness, I mean, I understand this, Mr. Lane, I think based on the way the case was presented, the jury would make a determination on what he did and did not hear. But at least based on my recollection, the word delusion and delusional compulsion was used throughout the course of the trial. In fairness to the state, because I have an obligation to be fair to all parties, The defendant is presumed innocent unless until proven guilty, but the state did request this charge. I will give 41 over objection, exceptions noted, but I will give it. Exceptions noted, it's in the record. In objection 42, that is insanity,
No.
mentally ill at the time of the alleged act.
No.
All right, we'll give 42 without objection. 43,
No objection.
you gonna tell that one, Ms. Venuto, on 43? There are three things in parentheses, Ms. Venuto.
Yes, Your Honor.
Mental illness, you want deleted?
No, Your Honor, actually, no. Since that's one of the options.
Look at the proposed verdict form. I see it. That is option number, yeah, I see it. I will give it in its entirety, Ms. Jeffries. All right, that's going to be 43 we'll give. All right, now, lawyers, on 44, the stipulations, the way that's drafted. Well, first of all, any objection to 44?
No,
Then, Ms. Venuto, what language do you want us to specify?
Your Honor,
The parties have entered into a stipulation, there were several, that have been approved by the court about the following, and it has in parentheses, facts, testimony, common documents, exhibits. Go ahead and write those out, Mr. Venuto. How do you want us to read? Because it says it's supposed to specify.
Yes, Your Honor. Those were specified specifically when they were read to the jury or when they were stated to the jury. Since those stipulations are not going back, the state would have no objection to doing something along the lines of previously stipulated documents, previously stipulated statements, that sort of thing, and just. I know it says to specify it, but instead of going through each individual one, they've heard all that information, both sides.
I'm just trying to make sure we have an agreement on what you want me to say as far as the charge. Well, let me see what Mr. Land's position is, because if she agrees with you, that's what I want to do. Do you agree, Mr. Land?
Judge, out of an abundance of caution, I guess probably the better course would be to have you read the 3 stipulations to the jury.
And that's fine, Your Honor. The state has no objection to that. I just didn't know if we had to go through each one of them.
No, I'm not reading. I'm not doing. No, because if I read these stipulations, to me that probably make a comment about what's written in these stipulations. So, yeah, say because you have in the stipulations 1, Andrew Sneiderman was charged and found guilty in 2013 of several counts of perjury, false statements, and hindering the apprehension of a criminal in connection with the investigation to the murder of her husband, Rusty Sneiderman. 2, she is not available to be called as a witness in this case by either the prosecution or the defense. And then also you have, others in here. No, I'm not going to read. Like 1, Andrew Sneiderman was staying at the Hampton Inn in Longmont, Colorado, from July 18th through the 23rd, 2010, called the front desk to request that her room be changed to one with a larger bed and to change the reservation from 1 to 2 people. Now, if I read these, I don't read. I'm not reading evidence into the record.
Okay.
So that's not going to happen. So you got another suggestion? Because that would be like I'm making a direct comment on what the evidence was or was not.
Perhaps the state and I can, after we're finished with this conference, get together and propose some language to the court after we discuss it.
Yes, and I give you a suggestion, and maybe something just along the line. The parties have entered into a stipulation that has been approved by the court about the following, about facts and circumstances and documents, period. That's it. Because I'm not going to, so if you come, because I think it'd be a direction, you have on here, AT&T records and cellular phone numbers. I'm not going to comment about the evidence.
And that's fine with the state, Your Honor.
And now all of these can be used in your closing arguments, but other than just a generic term that certain facts have been stipulated to by the parties and accepted by the court, period, that's it.
So facts, circumstances, and documents?
Right, period. That's it.
Fine.
That's in this case. Where parties stipulate testimony documents, exhibits only. This is in the nature of evidence. You may take the testimony as if it were given in court, and you may rely on it if you find it credible. However, either party may dispute such testimony by other evidence, period. You make all decisions based upon the evidence in this case. Mr. Woodward, is that this? Did you just? Is that a, Mr. Jeffers, let me tell you, like at 1.3 or 0.12? Are 3 paragraphs in 1.3 or 1.2?
I copied it directly from,
I'm
yeah.
pretty sure you did. I was just not sure.
It does look like it says a lot of the same things, Your Honor, but yes, it's directly, to my knowledge, I copied it directly from the patent charge.
I'm going to go for it. Is it exactly the same?
The difference, Your Honor, I think, is in the second paragraph, they're talking about stipulating to facts, and in the third part, they're talking about stipulating specifically to testimony documents or exhibits. The state has no objection if the court feels like it would be repetitive to just combine it all into one paragraph and not have it be that repetitive in the second
Well,
paragraph.
actually, that third paragraph is probably more inclusive of that second paragraph. So what I will do, Lord, is just give that third paragraph, because it says where parties stipulate testimony, documents, exhibits, and that's pretty much what you have done. Only, this is the nature of evidence, period. You may take that testimony as if it were given in court, comma, and you may rely on it if you find it to be credible. Semicolon. However, either party may dispute such testimony or other evidence, period. You make all decisions based upon the evidence in this case.
And would you be taking out that same portion of the however, either party may dispute such testimony by
No, I was
other?
going to leave it in.
Oh,
Because, I mean, that's more inclusive. So the way it would read is that the parties have entered into a stipulation that has been approved by the court about the following, or about following facts, testimony, and documents, period. And then I would just pick up where parties stipulate testimony, documents, exhibits. That's what you have done. Because it is testimony, documents, and exhibits. Only this is in the nature of evidence. You may, I'll just read that paragraph.
that's fine, all right, thank you.
Mr. James, since you're doing closing arguments, that's okay?
Yes, sir.
All right. Mr. Lane, is that okay with you?
Yes,
Since you're doing closing arguments.
Yes.
Okay. 45. It's not existent. You at least follow. All right, let's turn our attention to the defense lawyers, and we'll follow the same procedure. And lawyers, if both the state and defense are asking for the same request for a law to be given, even if I said I'm going to give them, I'm not going to give it twice. I'm going to give it 7. So just to move along, any objection to defense number 1, which is presumption of innocence?
No, Your Honor.
Number 2, grave suspicion.
Yes, Your Honor.
What's the objection?
The issue with grave suspicion, it's not an issue of grave suspicion as to whether or not he committed the offense or committed the act as this charge would normally apply in a situation like that. It's a question of he admits he committed the act. It's an NGRI issue. So we would say that grave suspicion really doesn't apply in this particular set of facts.
Mr. Land, you want this?
Now, we'll withdraw, Judge.
All right, that's withdrawn. Number 3, stipulation. Covered that already. Covered. Number 4, credibility of witnesses.
We've covered that already, Your
That
Honor.
will be given as far as covered. Expert witnesses.
We've covered that.
That is covered. We'll give. That's 1.3, 1.30. Number 6, witness impeached. We covered. We'll give.
You're still giving the second part,
The
Your Honor?
latter. That's
Thank you.
correct. We'll give. Prior statement.
No objection.
7.
We've covered that.
Covered. Now, well, you did not ask for this one. Number 8, the objection that the defendant did not testify.
No, Your Honor.
Now, the way it's worded now, it does say, I mean, this is what you wrote down. I know this is a new version. Not required unless requested. So, is this what you requested?
Yes, Judge.
Okay. So I will give it, Ms. Jeffries, the way it's written, number 8. That is 1.3210.
Your Honor, the only issue that we have is in that first paragraph, the parenthetical portion that says you should evaluate such testimony as you would have that of any other witness.
Right. That should come out.
So you want that out? Yes. Okay, Mr. Lamb wants it out, so it's coming out. So it's going to read, the defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. However, the defendant does not have to present any evidence nor testify. If the defendant chooses not to testify, you may not consider that in any way in making a decision. Any objection to the way it's going to be read?
No.
Ms. Jeffries, you agree with those changes? Okay, number 9, Ms.
Your Honor, we've already covered that one with the states.
Number 10,
We've covered that one as well.
11,
Covered that one as well.
12,
We've covered that one.
13, covered. 14, no presumption of criminal intent.
We've covered that one. That states
Okay.
number 17.
15,
Covered.
covered. 16, sympathy. Now,
We've covered that one, I think. Ron.
we did.
Yes.
Now, the second part of that, okay. Section. Miss 1711. Do you want me to put that second part in there, Mr. Lane? Where it's about race, creed, color, religion, national origin? No. Mr. Deland, this is your request. Sexual preference. All right, Kelly, we're back on order. Yes, Mr. Land.
Judge, we can withdraw that last paragraph.
Okay, so
Take that
Ms.
out.
Venuto will see, we're just going to get the first paragraph on that sympathy.
That's fine, Your Honor, thank you.
So we'll not give Ms. Jeffries, I'm going to give you a copy of the second paragraph. Page 17, defense 17.
That's been covered, Your Honor.
18.
That's been covered. With the portions that were being removed
That is
already.
correct. 19.
That's been covered, Your Honor.
Covered.
20 has also been covered.
20
And you would take
covered.
out-
Striking out mental retardation.
That's correct. I mean, it's the same one, it's the same modification. 21.
Your Honor, we would object to 21. 21 is actually covered in the pattern charge at the bottom of pattern charge 3.8020, which is state's charge 40. It's the portion that says, should you find the defendant not guilty by reason of insanity at the time of the crime, the defendant will be committed to a state mental health facility until such time, if ever, the court is satisfied that he should be released pursuant to law. That covers the same thing here, which says the trial court and not mental health professionals will decide when, if ever, a defendant is found who is found not guilty by reason of insanity should be released from a mental institution. It's the same principle is covered by the pattern.
Mr. Lane.
Judge, I think that 21 is a little more, gives a little bit more information and clarity in stating that the trial court and not mental health professionals will decide. And so we would ask that 21 be given.
If it's not pattern, we would just ask that stick with the pattern charge that actually covers this same exact principle. Might not use the wording the defense wants, but it covers the same exact thing.
I will not give 21 over objection. It'll be noted, but I will not give 21. Will not give. All right, Lori, we've gone through those. Are there any supplemental requested jury charges at this time?
None from the state, Your Honor.
None from the defense.
1 second. All right, Kelly, we're back on the record. All right, lawyers, that will conclude the charge conference. At this point in time, you have been notified of what law the court intends to give starting on Monday. I did make one additional request from your bench. If you could get with Kelly either now or when you return from lunch, just to identify those things that you know and you agree on that will, quote unquote, go up to the jury. If you could separate those things, now you're going to have them at your full disposal during your closing arguments, but it just will move along. The plan will be just to give everyone some logistics. Monday morning, we'll start with closing arguments. The law allows the state to open and conclude, and the state can make a determination on Monday morning or whether or not it wants to open and conclude. Just hopefully everyone will just be prepared to go forward. The law allows up to 2 hours each side to give concluding remarks. As the lawyers remember, we did have one of the jurors who had mentioned earlier in the process, and she had only exercised that once, that she had a gastrological challenge, and sometimes she has to go to the restroom prior to the break. She only did that once in the last couple of weeks. But my intent is not to interrupt you during the course of your closing. However, at least my philosophy is when you have volunteers taking their time to come out and serve as jurors, the intent is not to embarrass anyone and make them feel so uncomfortable or have them make a decision that they should not have to make about whether or not they need to use the restroom. So if they indicate during the closing, they need to have a restroom break, I'm going to give them a restroom break. So hopefully that will not, and you're professionals and you've done many closing arguments, it will not break your concentration. Any other questions before we break for the weekend?
None from the defense.
None from the state.
All right. With the Assistant Deputy Moore, I believe the jurors have left the floor. Lori, thank you very much. We'll see everyone tomorrow morning.
All right.